The drama over NDA's so-called UMEED is boiling over. Violence erupted in West Bengal and Assam even as protests continue from Kashmir to Tamil Nadu and Manipur to Maharashtra. The Waqf Amendment Act 2025 is at the center of a firestorm. And amid the drama, the Supreme Court is hearing north of 70 petitions. Well, in the backdrop, horrific scenes emerged from Bengal's Murshidabad, even as Chief Minister Mamata Banerjee blames India's border security force and the BJP accuses the TMC of provocation and appeasement. The Supreme Court has reacted to this entire situation. With conspiracy theories abound, the top court called out the violence as very disturbing. Interestingly, the Solicitor General representing the Government of India urged that violent protests should not turn into pressure tactics. So what exactly did the Supreme Court decide in the very first hearing against the Waqf Amendment Bill? What is Waqf by user? How did the centre defend the new Waqf board? Why has drama erupted over Muslim CEO? Well, let's find out.
अगर वक़्फ़ एक्ट को चेंज करना है तो क्यों कॉन्स्टिट्यूशन अमेंडमेंट नहीं किया?
Unconstitutional, illegal and anti-Muslim. This call for insaf is being countered by the central government calling for reforms. From the Chief Justice proposal to Kapil Sibbal's arguments for the petitioners, we take you through the courtroom drama as it unfolds on April 16th.
इन्होंने जो है ये अनकॉन्स्टिट्यूशनल जो चीज़ें इसके अंदर रखी है, हमें पूरी उम्मीद है कि हमें इसमें जो है हमें पूरा भरोसा है और पूरे हिंदुस्तान को इसमें यकीन है कि सुप्रीम कोर्ट से हमें इसमें इंसाफ मिलेगा।
ये नहीं चाहते कि ये जो देश के संशोधन के बाद गरीबों को, पसमानदा को, पिछड़ों को, मुसलमानों को या महिलाओं को उनको जगह मिलेगी वक्फ बोर्ड में।
The Supreme Court on April 16 made several big observations while hearing multiple petitions challenging the constitutional validity of Waqf Amendment Act 2025. A major point of contention has been the inclusion of non-Muslim members in the central and state Waqf boards. The Apex Court asked if the BJP-led centre would allow Muslims to be a part of religious trust of Hindus. A Chief Justice of India-led bench noted that undoing Waqf by user would create several issues. The court has sought the central government's reply to over 100 petitions challenging the act. However, it refused to put a stay on the operations of the law. So what does it mean? Now let's dive a little deeper on what the Apex Court said on the removal of Waqf by user provision. The top court noted that most of the mosques were built in the 14th and 15th centuries and producing a registered deed was impossible. In fact, representing the petitioners, Kapil Sibbal argued that the abolition of the Waqf by user provision struck at the core of religious practices. In fact, the senior advocate also raised the Ram Janmabhoomi verdict. The removal of the provision is another point of contention, driving the anti-Waqf protest. Under the Waqf Act of 1954, properties could be designated as Waqf if they had long been used for religious or charitable purposes, even in the absence of official documents. The amendment does away with the classification, raising concerns and ambiguity over the legal status of many such properties. In fact, the Apex Court has also sought clarification over non-Muslim members in the Waqf Council. The Supreme Court asked the centre if they would allow Muslims to be a part of religious trust. According to the Act, in the Central Waqf Council, up to 2 of the 22 appointed non-ex officio members may be individuals from the non-Muslim communities. State Waqf boards may include up to 2 non-Muslim members among the 11 appointed positions. India's top court refused to pass any sort of interim order, instead proposing a middle path to both sides. In response, the Solicitor General asked further hearing of the case. The matter was scheduled to be heard on April 17, and if history tells us anything, more drama is on the way.